the City of West Hollywood tonight on Thursday, March 11th, 2021. I call this meeting to order. Please, everyone, follow me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. All right, Mr. Secretary, may we have a roll call, please?
Commissioner Bergstein.
Present.
Commissioner Copeland.
Present.
Karen Ayers.
Present.
Commissioner Kerpes.
Here.
Commissioner Maggio.
Present.
Vice Chair O'Keefe.
Here.
Chair Topshin.
Here, we have a quorum. Approval of agenda is our next item. Commissioners, do we have a motion to approve the agenda items before us tonight?
Motion to approve the agenda?
We have a motion to approve the agenda. Do we have a second?
Second.
We have a second. Mr. Secretary, may we have a roll call, please?
Commissioner Bergstein.
Aye.
Commissioner Copeland.
Aye.
Karen Ayers.
Aye.
Commissioner Kerpes.
Aye.
Commissioner Maggio.
Aye.
Vice Chair O'Keefe.
Aye.
Chair Topshin.
Aye. The agenda is approved. Thank you. Approval of minutes. Have the commissioners reviewed the minutes of our last meeting from February 11th, 2021?
Yes, I'll make a
minor
motion to
correction. I
approve.
already called in to staff in that during my comments, I said that meeting might be my last meeting. As you can all see, I'm still here. Council has not yet tackled at-large appointments. They will do so next month. So I'm here for a bit longer. So that's the only correction I have to the minutes from our last meeting.
I object.
It's a pleasure to see you, Rob, again.
With
Thank you.
that correction, I ask that we approve the minutes.
We have a motion to approve. Is there a second?
Second.
Second.
That was Vice Chair? Yeah. We have a motion and a second. Mr. Secretary, can we have a roll call, please?
Commissioner Bergstein.
Aye.
Commissioner Copeland.
Aye.
Karen Ayers.
She can't vote on the minutes. She's not sworn in yet.
Yeah, I was going to say I abstain, but whatever is
Yeah.
proper.
Commissioner Kerpes.
Aye.
Commissioner Maggio.
Aye.
Vice Chair O'Keefe.
Aye.
Chair Topshin.
Aye. Minutes have been approved as amended. Thank you all. Public comments is next. Mr. Secretary, do we have any speakers at this time? Not related to the appeal.
I'm sorry, not at this time.
Not at this time. All right. Very well. Thank you. Okay, with that, we're going to move on to the manager's report, and acting rent stabilization and housing manager, Mr. Jonathan Hollop, is here.
Good evening,
Hello.
Chair, Vice Chair, Commissioners. Jonathan Hollop, Acting Manager, Rent Stabilization and Housing Division. First of all, I'd like to welcome soon-to-be Commissioner Ayers to the Commission. I look forward to working with you. And I'm glad to see that Commissioner Bergstein is still with us a little bit longer. Nice to see you. For the look ahead, tonight we have one appeal. We'll also be discussing amendments to the temporary relocation ordinance. Our next meeting will be discussing valuation guidelines, and staff will possibly be presenting an amendment at that time. We do have a couple of appeals that are not calendared yet. They did just come in, so I expect in April and May we'll be hearing those. Yeah, on April 22nd, we'll be discussing the adjustment of security deposit interest formula. And on May 13th, I put the general topic of regulation amendments. We likely have a lot coming down the pike, including ones that I just mentioned. So just a preview of some good stuff to come. I wanted to update the Commission on Council's directive on ways to maintain and increase the city's affordable housing stock. It's a very brief update. I just wanted to let you know that staff is currently working on the Affordable Pilot Housing Program report, and that will be going to Council at its May 3rd meeting. So keep an eye out for that. I also wanted to let the commission know and let the public know that on Monday, the City Council will be considering an extension of the local eviction moratorium. As a reminder, residential evictions are prohibited in the state and West Hollywood for non-payment due to COVID-related reasons through June 30th of this year. In West Hollywood, non-payment not due to COVID-19, using a unit for an illegal purpose, creating a dangerous or unsanitary condition, or an imminent and objectively verifiable threat to the health and safety of someone in the unit are currently the only permissible reasons for eviction. That prohibition is currently set to end on March 31st, but again, the City Council will consider this coming Monday, the 15th, whether to extend the local moratorium through June 30th, 2021. And that's already on the agenda, which is posted at weho.org. And you can tune in to the proceedings through WehoTV there. And that concludes my report. Thank you.
Thank you, Mr. Manager. Questions to the manager? Commissioners, any questions? I would like to ask Mr. Holub, the extension of that moratorium, everything remains the same, right? There are no changes.
No substantive changes.
Okay, would that recent SB 91 bring any changes? Will have any effect on the rent stabilized properties and non-rent stabilized? Basically, it's about non-rent stabilized. Would that have an effect on the properties?
No, SB 91 fundamentally extended the existing moratorium through the end of June.
Okay. All right. I don't have any other questions. With that, if there are no more comments from staff, we are ready to move on to the oath of office. And we have a new member joining the commission tonight, and Mr. Holub, who is going to administer the oath of office?
Commissioner Erickson will be joining us, but he hasn't quite joined us yet. He's not in the waiting room yet. I believe my understanding is he had another oath of
Who is that?
Commissioner or Councilmember Erickson.
Oh, Councilmember Erickson.
Who has just entered the waiting room. So I'll admit him now.
Okay, so we'll wait a few seconds. Good evening, Councilmember Erickson.
Hi, everyone.
Hi. Welcome back.
I'm back.
It's always a pleasure to see you here.
Always wonderful to see you too.
All right, so we have a new member, and you're going to administer the oath of office.
Yes, I am. Thank you. I was on another board meeting because, as we all know, the Lesbian and Gay Advisory Board meets at the exact same time. So I just got done swearing in our city's first ever bisexual member of the Lesbian and Gay Advisory Board. But I'm so glad to be here with all of you. I just want to say a few words to thank you all for your service. I also want to thank former Commissioner Charity for his service to this commission. Really appreciate all the service he's done to the city. He's such a great individual, and I'm so glad to have his commitment to all of the things that we care about. I'm so excited to appoint Karen Ayers to this commission right now, a renter and someone that I have trusted with so many things, and I trust most with the renters of our city and making sure that our rent stabilization ordinance is not only strong but enforced. And I'm just so proud of you, Karen, and I can't wait to administer this out. All right, are you ready?
Sure.
Okay, here we go. Raise your right hand and repeat after me. I, Karen Ayers,
I, Karen Ayers,
do solemnly swear
do solemnly swear
that while serving in the office as a member of the Rent Stabilization Commission
that while serving in the office of the Rent Stabilization Commission
of the City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear truth, faith, and allegiance
the Constitution of the United States,
to the Constitution of the United States,
the Constitution of the State of California,
and to the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation or purpose of evasion,
without any mental reservation or purpose of evasion,
and that I will well and faithfully
and that I will well and faithfully
discharge the duties upon which I'm about to enter.
that I will discharge the duties upon which I'm about to enter.
Congratulations, Commissioner.
Thank you. Thank you, John.
Have a wonderful meeting, everyone.
Thank you.
Bye.
Thank you, Council Member. Welcome on board, Commissioner Ayers, and it's a pleasure to have you and on board. And hopefully, I'm sure you will be a great addition to this commission. And thank you.
Thank you.
All right, with that, commissioners' comments will be the next item. Commissioners, I can go in alphabetical order. Commissioner Bergstein, please.
First, Commissioner Ayers, I just wanted to really welcome you to the Rent Stabilization Commission. I'm very excited that Councilmember Erickson appointed you. I know you'll be a true asset to the commission and the tenants and landlords in the city of West Hollywood. Your predecessor leaves you big shoes to fill, but I have utmost faith in you. I wanted to also give a brief update. For those of you who've been on the commission for a while will remember that I brought forth the concept of a smoke-free housing ordinance nearly 4 years ago at this commission, and it took a while to wind its way through us and through council, and what was to have been the second reading on the consent calendar 2 meetings ago was a very weak ordinance. It essentially prohibited smoking in new tenancies, but allowed the existing smoking tenants in perpetuity to remain smoking in their units, which would have exposed all of those tenants, both in place and following, to toxic secondhand smoke in their own homes. And I want to thank Councilmember Erickson for pulling that item from consent, bringing it back for a fuller discussion at the last council meeting. And they did agree to a calendar of 1 year from, I believe it's April 1st, that all existing tenancies will also become smoke-free. So while it is not a perfect ordinance, that was a huge step in the right direction for protecting the health of our non-smoking residents from exposure to secondhand smoke. So again, I want to thank Councilmember Erickson for having second thoughts about his original vote and bringing it back. And we had 4 out of 5 council members approve that. So it was a long process, but very happy that as I'm exiting this commission, I can leave on that happier note.
Thank you. Commissioner Copeland.
I just wanted to give a warm welcome to Commissioner Ayers. I look forward to working with you, and we're very familiar with your dedication to the city of West Hollywood already, and I'm sure that you'll be a wonderful addition to the commission. I'd also like to thank Commissioner Charity for all the work that he did on the commission over the years, and it's much appreciated. Commissioner Burks, I'd also like to thank you for your work on the smoking ordinance that you just spoke of. I think it's very important, and we've come a long way on that. And I know that you've worked very hard on that too. So thank you for that.
Commissioner Ayers.
Hi. Well, thank you for the warm welcome. I just want to let you know that, I am a longtime resident of the city of West Hollywood. I've been here for almost 20 years. I know there's people who are here a lot longer than that, though. And I've love the city of West Hollywood. I am a renter, but I'm also the daughter of a landlord and a property owner, and I can see both sides. I hope to fill my responsibilities with a focus on fairness and just having a thorough understanding of the cases and consideration of what the city advises. But I'm really happy to be here and excited about this work. This is an important commission, and I'm honored to be part of it. Thank you.
Thank you, Commissioner. Commissioner Curtis.
I just want to congratulate and welcome Commissioner Ayers. Welcome aboard. I'm very excited that you're with us. And then I also want to, if Commissioner Charity is watching, to thank him for his service. It was real honor and privilege to serve with him. Thank you.
Thank you. Commissioner Maggio.
No comments at this time.
Thank you, Commissioner. Vice Chair O'Keefe.
Just echo the warm welcome to Commissioner Ayers. I'm very excited to have you on board, and also the gratitude for former Commissioner Charity's great service to the commission and the city. Listen.
Thank you. I too would like to again congratulate and welcome Commissioner Ayers to the commission, and it will be a wonderful asset based on the comments we just heard for Councilmember Erickson and Commissioner Bergstein. And I also want to thank Commissioner Charity for his wonderful service on this commission, and he will be missed. He's a wonderful individual, and he's a great attorney from what I heard, what I know, and he definitely will be missed. And he's a great service to the city for those few years that he served as a commissioner on this Stabilization Commission. Thank you, Commissioner Charity, for your service. All right. And another thought, since we touched and Commissioner Bergstein touched that, and Commissioner Copeland also made a comment regarding the smoke ordinance. I too agree that we need that ordinance for the city, but we have to be very careful. We don't want to open the door for the evictions for the long-term tenants. And I believe there was a state law that was passed a few years ago, and that those ordinances are echoed in the rent control jurisdictions, anti-smoke or smoke ordinance, whatever they call it. But the state law guaranteed grandfathering the rule for long-term tenants who were there, and I believe that the law said that new rules that would apply to new tenancies. So I think whatever was proposed was exactly echoed the state law, and I think we have to be careful in this. But I'm sure that the council knows what they do, but if needed, we can bring this up and at the next meeting sometime, and maybe make some recommendations if needed. I don't know if it's appropriate, but we can ask our manager.
I can also just clarify that
we move for. I'm sorry.
I can just clarify that Councilmember Duran, when he was on council, had a motion where smoking is not considered a nuisance in West Hollywood. So a violation of the smoking ordinance would not be a basis for an eviction in West Hollywood. I'm not an attorney, but I'm not aware of any state laws that codify that, and I haven't heard of that affecting smoke-free ordinances in Berkeley or Santa Monica or Beverly Hills. But our local ordinance, it is an administrative fine process with teeth on it, but it is not an evictable offense. I will say that from our research at the other jurisdictions, there has never been a tenant that has had to be considered for eviction because of violation of smoke-free ordinances. Smokers find another way to smoke and comply with the ordinance. That's been the history.
Okay. All right. Thank you, Commissioner. So with that, I think we should move on to the next appeal section of tonight's agenda. And we have one appeal scheduled at this time, and that is application D-4503CD, pertains to the property address 1009 North Heavenhurst Drive, which has to do with the restoration of the rent reduction. This appeal has been filed by the tenant. Yes, by the tenant. As a reminder, commissioners, please make sure your video is on and you're always visible the entire time during this appeal. In case if you will need a short break, just let me know. Mr. Secretary, I would like to confirm at this time if both parties are present and the connection is set properly for them to speak.
Yes, we have both parties in the meeting.
Wonderful. So before we begin, I would like to take this moment and explain the appeal process for the parties. First, the commission will hear the staff report presented by the department's legal counsel, Mr. John Natalizio. Then commissioners may direct their questions to the legal counsel. And following the legal counsel's report, each party will have 5 minutes to address the commission and present their case. The appellant in this case is the tenant will go first, and the respondent, the property owner or the owner's representative will go next. The appellant, the tenant, may divide the time between the presentation portion and the rebuttal portion of the argument, and the respondent will take the entire 5 minutes. And after that, the commission will begin deliberations. But as a reminder to both parties, please do not bring any new evidence or information, new documents that will not be reviewed by the commission, because tonight's appeal is not a second hearing. The commission will only review the grounds for which the appellant believes the hearing examiner's decision is incorrect. So therefore, new evidence will not be considered by this commission. And the legal counsel or I may interrupt you at any moment if you go off topic or try to introduce any new evidence or information. So with that said, Mr. Natalizio, we are ready for your report.
Good evening, Chair, Vice Chair, Commissioners. It's great seeing you all again after a little break. I want to welcome as well Commissioner Ayers, and also say I'm happy to see Commissioner Bergstein back as well. So I am the legal counsel to this commission. This appeal was filed by Thomas Dennis, who is the tenant for a property located at 1009 North Havenhurst. The property owner is Stefan Separinia. This hearing involves an appeal of a compliance determination. Mr. Dennis originally applied for a rent decrease, alleging various repairs were needed, and relevant to this appeal are interior repainting and repairing of cracks in the interior of the unit. A hearing was held before a hearing examiner, and he found, among other things, that the maximum allowable rent was to be reduced by $154 for the various repairs, including $14 for the interior painting and crack repair. As it relates to that $14, to have the rent restored, the owner was ordered to perform all acts reasonably necessary to repair the cracks in the walls and ceilings and repaint the repaired cracks to match the adjacent areas. The owner submitted a request for a compliance determination to have the rent restored regarding interior painting and repair for the cracks. The owner submitted an invoice and photos as evidence of the repairs. The tenant filed an objection with photographs claiming that no work to remedy the deficiencies had been performed. The city then conducted an inspection through a code compliant officer to determine whether the owner had substantially complied with the hearing examiner's decision regarding the repairing of cracks and repainting of the interior walls and ceiling. The officer generated a report and photographs which were submitted to the hearing examiner. After considering the evidence, the hearing examiner issued a decision on the request for a compliance determination. The hearing examiner found that the unit's interior was repaired and repainted in substantial compliance with his original order. The hearing examiner ordered a $14 rent restoration for the performance of the interior repairs and repainting. Mr. Dennis's appeal only challenges the hearing examiner's decision regarding the restoration of the rent for $14 for the repairs and repainting of cracks in the interior of the unit. Mr. Dennis alleges that the owner did not repair any cracks or repaint repaired cracks to match the existing paint. Mr. Dennis makes additional claims that the owner is not complying with an agreement to repaint the interior generally, and has not repainted the unit's interior in over 8 years. Mr. Dennis includes several photographs with his appeal. Staff has reviewed the hearing examiner's decision, the compliance determination, and the appeal application, and recommends affirming the hearing examiner's compliance determination and adopting resolution number 21-588. Staff agrees with the hearing examiner's findings that the owner substantially complied with the hearing examiner's order. The landlord submitted an invoice with photos regarding the work performed, which is supported by a city inspection report and photos. Staff believes that Mr. Dennis's arguments regarding an agreement between himself and the owner is not relevant to this appeal and was not a part of the compliance determination. Staff also believes that Mr. Dennis's argument about the unit not being repainted in over 8 years is not relevant to this appeal as it was not a part of the compliance determination. Lastly, staff believes that the photos submitted with the appeal application were not submitted to the hearing examiner before the compliance determination and thus were not considered by the hearing examiner. Therefore, staff believes that this is new evidence the commission should not consider. You as the commission have the power to affirm, reverse, modify, or remand the appeal determination of the hearing examiner as you deem fit. The commission reviews the hearing examiner's compliance determination under the substantial evidence standard, which requires the commission to make sure that there is substantial evidence that reasonably supports the hearing examiner's decision. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The commission does not substitute its judgment for that of the other hearing examiner or reweigh the evidence. In this specific instance, your review of the hearing examiner's decision is to determine whether there is substantial evidence to support the hearing examiner's decision that the unit's interior was repainted and repaired in substantial compliance with his original order, and that the $14 rent restoration was warranted. Thank you.
Thank you, Mr. Natalizio. Commissioners, do you have any questions at this time to the council? I didn't see any. No questions? All right. If none, then I will open the oral argument portion of tonight's appeal, and I will invite the tenant, Mr. Dennis. Yeah, we just want to make sure that it has connection.
Yes.
All right. Yes, sir. Hi. Since you filed the appeal, you will have the opportunity to divide your time 5 minutes between the presentation portion of your argument and the rebuttal.
Okay.
Would you like to do that?
Sure. I will give the presentation part now, and if there is time, I'll save it for the rebuttal. Yeah.
Yeah, you need to state how much time you want to take for your presentation part.
2.5 minutes. 2 minutes.
Okay. 2.5. Perfect. Mr. Secretary, please note that 2.5 minutes now and 2.5 minutes later. With that said, sir, you may begin. Please state your name and the city of residence for the record, and you can take your 2.5 minutes, sir.
Okay, my name is Thomas Rowley Dennis, City of West Hollywood, address 1009 Havenhurst. The hearing examiner decisions were made on March 11th after the hearing on February 3rd, as we just heard. And during the hearing, the landlord, in fact, agreed to the painting of the interior of the house in front of the examiner, myself, and my lawyer. The landlord had originally claimed he did not need to paint the interior of the house, as I painted one of the walls blue, but nothing in the lease that said I couldn't do that. But after the hearing examiner explained and referenced RSO 1756010, requiring that the interiors be painted every 4 years, he agreed that he would paint it. In the hearing notes, the hearing D4503, that conversation is clearly represented by the hearing examiner, and quoting from those notes, the parties have apparently agreed to new interior paint for tenants' forbearance from future painting. As the ordinance clearly states, interiors should be painted every 4 years. The walls in this unit have dark patches around lighting, uneven patchwork of paint on walls, yellow stain in the cracks and on the paintwork. And in the almost 9 years I've been here since my move-in date in May 2012, neither the interior paint or cracks have been painted over once. Furthermore, issues raised during the hearing is that he has raised the rent in every year in December 2016,
but that's irrelevant.
December 19, certifying that it was in compliance, but it wasn't. So I'd like the record to reflect that he has not painted the interior of the property the 2 times that he should have in the last 9 years, or mended the cracks, but he's also raised the rent multiple times, knowing that it's not up to code. The images that were submitted were also submitted in the original hearing, and also any cracks that have been mended by myself. Here's the receipt to prove it. And he has not done any of the maintenance that he claims he's done or should have done in the last 9 years. Thank you. That's it.
All right. Thank you, sir. How many minutes he has for the rebuttal, Mr. Secretary?
Yes, 3 minutes remaining.
Okay, thank you. Commissioners, are there any questions to Mr. Dennis? Not at this time. All right, thank you. I will invite the property owner, Mr. Stefan Sahar Sepernia. I hope I pronounced it correctly. Sir, now it's your time.
Do you hear me?
Yeah, we hear you and we see you. Sir, since you're responding, you have to take your 5 minutes at once. And as I said before, so no new evidence, just state your name, city of residence, and you may begin.
Yes, my name is Stefan Sahar Sepernia, and I'm the owner of 1009 Havenhurst Drive in West Hollywood. And my address is 938 Northcroft Avenue, Los Angeles. Okay. After the second hearing, January 17, 2020, I came to the city and I requested the city code compliance officer to come to the unit to document and take pictures of all the disputed areas that the tenant has requested for repair. I wanted to make sure that the city has filed and has documents prior to me repairing anything. And the city code compliance officer came. Both of us went through all the list to every area, and I showed him all the cracks and holes that the tenant has been claiming were nothing but hairline. There was one chip paint above the stove in the ceiling in the kitchen. The rest were all hairlines. The city code compliance officer took pictures and documented prior to me repairing anything. Immediately after that, in February 2020, I started the work and the repair took almost 2 weeks, and I finished February 28, 2020, prior to the decision issued before March 11. So I everything that was needed to be done, repairs, paints, fixing, I've done them all. And after I asked the city code compliance officer to come back to take pictures and document every single area that was again in question. And he documented that everything was done. After that, I had sent all my pictures, all the invoices, that all the work that was requested about the cracks that was disputed and the whatever holes he was talking about, everything was done. Everything was fixed. The whole kitchen ceiling was painted. All the other areas were painted matching the adjacent walls. Everything was painted except later on, the tenant comes and says no work has been done. Well, we were there for 2 weeks. We have witnesses. And also the city code compliance officer came before the repairs and after the repairs. And they sent me that they have approved that all the work was done. After doing all of this work, the tenant also has a long list of things that I've done for him. And over the last 8 years that he has been tenant, there has been numerous things that has been replaced and fixed. So there is nothing that needed to be done. This $14 that was granted, the reduction, the tenant has been disputing it. The work was done February 28, 2020. A year has passed and still the tenant is enjoying the reduction of the rent, plus he has been taking money off the rent, whatever he has been wanting, that totals to an extra $860.72.
I don't believe that's relevant.
Okay, so not only many improvements has been done and all the work has been done, I'm continually getting complaints that nothing ever has been done with this unit. And I have 8 years full of receipts to show how many things that I've done. So this work has been done. If there has been July 5th, there was an earthquake of 7.1, and July 4th was an earthquake of 6.4 magnitude in 2020. If there are additional hairlines in the walls, that's not that I didn't do the work. I have done the work, and there is substantial evidence that I have done it. It's just this dragging this thing for a whole year benefits the tenant, and he's reducing money, and he's talking about things like rent raises, which was
that is your time. Your time is up. Thank you, sir. Commissioners, any questions to the property owner?
Yes, I have one.
Sure. Commissioner Maggio, please.
To the property owner, I'm just curious, when's the last time you painted the apartment totally?
It was 8 years ago. However, the tenant brought this up in the hearing, and there was a decision by the examiner, hearing examiner, that because the tenant has been using this house for his artworks as an art gallery / residence, he has painted walls black. He has writing on the walls, and he has tremendous amount of his artwork on all the walls. So there are big holes with gigantic nail holes in the walls. And this was brought up in the first hearing, and the hearing examiner looked at all the pictures of all the writings on the wall, rooms being painted in black. There are tremendous amount of 6 by 4 feet paintings all over the house. So this house has full of nails.
I think you answered the question, sir. Commissioner Maggio, are you satisfied with the response?
Yes, thank you.
Thank you. Other questions? Vice Chair O'Keefe, please.
Chair Topchin, if you don't mind, I apologize for interrupting. I just want to remind the commission that this is an appeal of the compliance determination, and repainting of the entire unit is not a part of the compliance determination. It might have been a part of the underlying hearing for 4503, but as it relates to this specific appeal of the compliance determination, that was not a part of the hearing examiner's scope decision or a part of the appeal.
Thank you, legal counsel. So that we're going to focus on that only. Yes, Commissioner Maggio.
The question was simply asked for information. Thank you.
That's okay. Yeah, thank you. Vice Chair O'Keefe.
Yes, so I first have a question for our legal counsel before I might have a question for the landlord. So the decision, the initial decision that this was a compliance determination request from, was it an order to repaint the entire interior or just to repaint some of the interior?
So the part that's at issue is, to answer your question, the part that's at issue is the repairing and repainting of cracks in the unit to match the adjacent wall or ceiling. If there was another order as it relates to painting of the entire unit or the exterior of the unit, that wasn't a part of the compliance determination and isn't a part of this appeal.
Thank you for clarifying. Okay, that's it for me then.
Thank you. Commissioners, no questions? All right, so let's bring Mr. Dennis back, and you will have, sir, you will have your remaining 3 minutes for your rebuttal. You may begin now.
Okay, thank you. Yes, so basically addressing what he said, the hairline cracks are all over the house, and that is why, I mean, they're cracks, they need to be fixed. The reason they're there is because the house hasn't been painted in 9 years. This was brought up in hearing D4503 as an issue. I don't know why now you're saying it's not an issue, because clearly the house needs to be painted, as it hasn't been painted once in 9 years, and it's supposed to be painted every 4 years. What happened in February 28th is there was part of the ceiling hanging off above the cooker, and he did repair it and paint the ceiling in the kitchen alone. That is true. I would appreciate if he could supply receipts for painting the entire house, which he can't because he obviously hasn't. And as far as me having artwork on the walls, that's what people have on the walls. So in my response, I think that clearly the cracks and paint are all through the house. So the whole house needs to be painted anyway. And plus that is the West Hollywood Ordinance that states it has to be painted every 4 years. And it should have been painted twice.
That's all. That concludes your.
Well, I wanted to ask legal counsel then if it applies to him painting over the cracks and the bits that need painting in the house. They're everywhere in the house.
Yeah, this is not the time to ask the legal counsel. This is just your time to address the commission. And
okay.
Yeah,
well, then I'd say that, you know, in the original request was to paint the house, and they're saying that it's the cracks that needs to be fixed. The cracks are all over the house, so I think they both need to be fixed. So.
All right. That concludes your statement, your report.
Yeah.
I mean, argument. Thank you. Commissioners, questions to Mr. Dennis? All right, I see none. And with that, I'm going to close the oral argument portion of the appeal. So then the commissioners, you may ask questions to the legal counsel if you have any. Any questions? Commissioner Kerpis, I thought your hand or no? Okay, so I think I had the question. Well, I think you responded to Vice Chair's questions pretty much. Echoes the same question, but yeah, my question was, Mr. Natalizio. So the owner mentioned a couple of times during his argument that he requested the inspector to go and check and take pictures, etc. So I don't believe that's a typical process. I believe the inspection can be requested by the examiner. Is that correct?
So in terms of if there was an inspection before the hearing, to my knowledge, that's not in the record before us. What is in the record before us is that the hearing examiner for the compliance determination requested that a city code compliance officer inspect the work that was done after the landlord filed the notice of completion for the work. And so that is the photographs in the report that is in the appeal packet.
So we're not saying that there are possible other inspections prior to the hearing or the appeal, right? It was just only, I don't know if there were any other inspections, or this is the only inspection that was conducted as per the examiner's request.
If there were other inspections, I can't attest to that. All I can look at is what the record says. And to my understanding, the record shows that there was an inspection done at the behest of the hearing examiner.
Okay. Yeah, I just wanted to clarify that and confirm that the request for the inspection was done not by the owner, but the hearing examiner. And that the hearing examiner has that authority and to request the inspection to be conducted as a neutral party to go in to see what's happening there. So that was something that I wanted to clarify, and I would probably have some more questions later on. But I wanna open the discussion with the commissioners. So commissioners would like to begin the discussion. Do you want me to go? Okay, Vice Chair.
I need to get up for just 1 second, turn my thermostat down. I'm
Sure.
getting too warm here. Give me 1 second.
Okay, all right, we'll wait for a second. Okay, Vice Chair O'Keefe.
Okay, so I thought I'd draw my fellow commissioners' attentions to the bottom of page 67 and the top of page 68, which is about I believe this is the original decision from the original case. And it found that the RSO, so the tenant, it appears, had asked that the entire place be repainted. Initially, it says that the rent stabilization section requires that housing units be painted every 4 years unless the landlord can demonstrate that new paint is not necessary or that its emission was caused by an intentional act of the tenant. And that decision found both exceptions apply in this case. as permitted in his lease. Mr. Dennis has himself painted much of the home, from a newly colored wall in the bedroom to a large graphic mural in the living room. The corridor is also covered with at least 9 attractive canvases that were painted by Mr. Dennis and nailed to the wall. If the purpose of the 4-year painting mandate is to ensure the proper appearance and upkeep of the housing interiors, it has been fulfilled by Mr. Dennis's conduct. So I found that useful after our legal counsel gave us the background. On the question of the specific issue, which was the patching of the cracks, it has been inspected. The hearing examiner found that the landlord had complied with the ordinance, and we as appellate body have to be deferential to the original, the hearing examiner. There's substantial evidence on the record. There's photographs. There's the neutral third party saying that it was repaired. So I would agree with sustain the compliance determination and agree with the staff report.
Thank you. Commissioners, actually, let's go by the alphabetical order. Commissioner Bergstein, that's the best, I think.
Have my next page. So I'll be voting in favor of staff's recommendation. Any agreement between the parties about painting the interior or not painting the interior is not part of our record. Normally, when a unit gets painted, it's the entire unit gets painted at once. But this is a different circumstance where the tenant is, I don't know if it's an art gallery or just displaying a lot of art, and has painted I think a poem on one wall. So the tenant has actually precluded the landlord from being able to have full access to the wall. So the only issue here is were the cracks repaired, and are we in substantial compliance? And from the report and photographs from Mr., I think it's Leva, if I'm pronouncing his name correctly, from code compliance, it's very clear to me that they are in substantial compliance. It may not be perfect, but it is within compliance. I do find the comments about earthquake crack to be, while perhaps interesting, irrelevant at this point. So as far as I can tell from the record, the report, and the photographs from the compliance inspection, we are in substantial compliance. I'll be voting to uphold hearing examiner's decision.
Thank you. Commissioner Copeland?
Yes, I read the record very carefully, and the compliance determination and inspection. I know we're only addressing the issue of the cracks at this time, and not the other issue that compliance inspected at the same time. But reading the record, to me, I feel was very clear that
I think we have a connection problem.
the examiner to determine having a connection problem. Can you hear
Yeah,
me?
we had a connection problem. Can you repeat that last couple of sentences?
Sure. Sorry about that. The examiner felt that the evidence was sufficient and substantial enough, and although it's not perfect, perhaps, as he stated, I believe that it was carefully weighed by reading the record and seeing everything else that was weighed and considered. And I think the evidence was substantial enough, and I would certainly support staff's recommendation at this point.
Thank you, Commissioner. Commissioner Ayers?
I too am planning to support the hearing examiner's conclusion. I think the $15 was specifically tied, according to the documentation, to the cracks, the repair of the cracks and the painting over of the cracked areas, and didn't apply to general interior painting. So I think it would be unfair to expect the landlord to not receive that $15, to not have that rent restored because of the interior painting, which was not tied to that $15. And it does seem that the city was very thorough in its documentation of the landlord's compliance with the repair issues tied to that $15.
I believe, just for the record, I believe it's a $14 rent reduction,
Oh,
right?
I'm sorry, 14?
Yeah.
I stand corrected.
Okay, thank you. Thank you, Commissioner. Commissioner Corpus.
Yes, I agree. It's not often that we get the opportunity to have a inspector involved in the case, and in this case we do. So I went back and I looked at on page 71 of our staff report, the hearing examiner's decision originally. Part D says repair all cracks in the walls and ceiling and repaint the repaired cracks to match the adjacent areas, restoring $14 of rent. That was the order. And then there was a time when the inspector went out. Page 46 of our staff report is the inspection report that says, yes, observed some fissures, cracks visible on some of the exterior surfaces throughout. And the answer to the question was, did the builder, I'm sorry, on the interior, as to the building interior, in your opinion, does the cracks and ceilings been repaired? And the answer is yes. And then we have the staff or the hearing examiner's compliance determination, which is very clearly what he based his decision on, was the pictures and the evidence that was submitted and ordered. The order matches the original order that he had stated in the hearing decision. And then I look at the appeal, what we're appealing, or what we're looking at tonight, and that's the interior painting, repairing interior cracks. So on that specific issue, I would say that the evidence is the record is very clear that the hearing examiner made the right decision.
Thank you. Commissioner Maggio.
Yes, I concur with my fellow commissioners, or the commissioners that have spoken thus far. The owner has definitely complied. All the proof and evidence is there. And we can only speak of this specific issue. Of course, the other issue of painting every 4 years, yes, that's our rule, but it doesn't apply here. So I'm going to have to vote in favor of this decision. Thank you.
Thank you, Commissioner. I just want to ask a question to the legal counsel. When can the tenant refile if the tenant wants to address those those cracks that he presented the pictures for, and that cannot be reviewed now? Is that after 6 months after this appeal, after the appeal date, or after the original hearing date?
It's 6 months from now.
From today's date.
Mm-hmm.
Okay. All right. Thank you. So it seems like everybody is, in agreement. I would say that definitely when I'm looking at the inspection photos, those cracks, they bother me. I have to be honest. This crack should not be there. That's the question. That's the bottom line. But we're not here to reweight the evidence, or the examiner. I'm sorry, reweight the examiner's decision on this compliance determination application. So this is, as the legal counsel specifically mentioned, that this is about the compliance determination based on the inspection report and based on the findings of the examiner. So I don't see, well, I see a substantial compliance. Yes, there are some cracks, and that was noted in the inspection report. And it's not something that was not noted by the inspector. This is not substantial, and therefore the examiner determined that this wouldn't cost $14. So that's why the rent will be restored. So yes, visibly looking at these pictures, I don't like the cracks, but would this rise to the point that the $14 rent reduction should stay? I don't think so. So because we have a third neutral party inspection conducted and reported that this is very minor. So now what I'm going to do is I'm going to support the staff's recommendation in this matter, but as I asked the legal counsel, from today's date, you will have 6 months. After 6 months, you may refile if those photographs that you have, and we would not review and comment on them, if those photographs you believe they substantially reduce your housing service, or they are habitability concerns of yours. So you can file a new complaint after 6 months and have that process start again. And hopefully at this time that will be resolved, and and the landlord will repair them, or they would find some other resolution. So, but that's going to be my vote today. I'm going to support the staff's recommendation. So with that, anyone would like to make a motion? Commissioners? Anyone? Okay, Vice Chair?
All right, I will move to adopt resolution RSC number 21-588, a resolution of the Rent Stabilization Commission of the City of West Hollywood making a determination regarding appeal D-4503 CD for property located at 1009 North Havenhurst.
I'll make a second to that motion.
Okay, thank you. We have a motion to approve, to affirm the examiner's findings and the staff's recommendation, and we have a second. Further discussion on the motion? I see none, so then we're ready for the roll call, Mr. Secretary.
Commissioner Bergstein. Commissioner Bergstein. Sorry. Commissioner Copeland.
Aye.
Commissioner Ayers.
Aye.
Commissioner Kirby.
Aye.
Commissioner Maggio.
Aye.
Vice Chair O'Keefe.
Aye.
Chair Topshin.
Aye. Motion passes, and thank you, everyone. And also thank you to the parties for being here and presenting your case before the commission. If you have any questions regarding the appeal tonight, please contact our Rent Stabilization and Housing staff. The telephone number is 323-848-6450. Well, now you will be placed back in the waiting room, and if you'd like to watch the rest of the meeting, you're welcome to do so, or you may also do it online, www.weho.org/WehoTV. Thank you. That concludes our appeal for tonight. All right. Commissioners, we can move on to the next item unless if anybody needs a break. All right, so let's move on to the next item, which is the new business. A new business, and we have a temporary relocation ordinance. The Rent Stabilization Commission will receive staff recommendations relating to amendments to the Rent Stabilization Ordinance provisions relating to landlord obligations to provide relocation benefits to tenants temporarily dispossessed of their dwelling unit due to necessary repairs, government order, termite treatment, or inoperative elevators, and provide feedback. So we have Manager Holub to report on this item. Manager Holub.
Again, thank you, Chair, Vice Chair, Commissioners. This provision of the RSO was amended in 2016 by the City Council in order to clarify grounds for requiring a landlord to provide temporary relocation to a displaced tenant. The amendment also provided more specificity to what housing and intending amenities must be provided to a tenant during the period of displacement. Staff experience since the last amendment has demonstrated a need for further clarification to ensure that tenants are receiving safe, decent, and convenient accommodations during periods of temporary displacement from their unit. In order to do so, staff has prepared a draft amended temporary relocation ordinance that integrates the following key changes: setting reasonable per diems for hotel and pet accommodations, along with meal and laundry allowances; setting forth that temporary accommodations be no further than 2 miles from any city border; creating a standard whereby senior and disabled tenants are given the option to receive landlord reimbursed essential services in their home or to be provided with off-site accommodations when an elevator has been out of service for more than 24 hours. This would also bring this provision of the RSO under the Administrative Citation Enforcement Program, which will allow for code officers to issue administrative citations for a landlord's failure to comply with the relocation requirements. Finally, the proposed amendment requires that substantive changes to the requirements within the provision must be agreed upon in writing between the landlord and the tenant and filed with the department. I look forward to receiving your feedback, and I'll consider any suggestions before bringing this item to council. But staff believes that the current draft amendment being presented offers a high level of protection, and the request this evening is that Commission recommend to the City Council approval of the proposed amendment and a tenant relocation amount draft resolution. That concludes my report, and I'm available for any questions.
Thank you, Mr. Manager. Commissioners, do you have questions? Okay, let's go by the in alphabetical order again. Commissioner Bergstein.
Hi.
It's easy for me.
Yep. It's my page. So I do have some thoughts and questions, and I'm sorry I'm on a different screen, so I can't see myself talking. Because I know one of the properties I helped manage, one of the tenants on the second floor thought it would be a good idea to take a sledgehammer to a toilet, which caused 2 units to have to be relocated for about 6 weeks into a hotel. And I know that hotel did not include parking with the rate. So first question is did I miss something? Is there a guarantee that when a tenant is temporarily relocated that the cost of parking their vehicles would also be covered? Because a tenant shouldn't have to bear that cost while they're being relocated out of their unit. Do you want me to continue or just give you all 3 questions at once?
I can respond to that if you want me to respond.
Yep.
Yeah. Well, the reasonable rates that were collected would presume to include parking, since they are GSA-based travel per diems, which would include parking for presumably for a business traveler. But we can certainly specify that parking must be included as part of the accommodation. And that wouldn't be something that shouldn't be included to make it clear. So I can certainly integrate that into the ordinance.
I know these tenants are relocated to a modest hotel on Sunset, but that approaches $300 a night and the parking was extra. So I'd appreciate if we could include that. I'm not, and I'd like to hear from my fellow commissioners, I'm not sure of the $35 per day per diem for meals, whether that is sufficient. Certainly if they're relocated to an apartment that has a kitchen or even some hotel rooms, that's different because they can bring in their own groceries. But if you're living out of a hotel and you have to get all 3 meals from restaurants or takeout, I'm not sure that $35 is going to be sufficient to cover a tenant's out-of-pocket costs for food. So I'll wait to hear my fellow commissioners comment on that. The charges for laundry, I think the $3 a day is excessive. And I'm talking from my own personal experience. We have 2 adults in my household. We generally run, I call it 1 1/2 loads a week, a load of colored, a load of whites every 2 weeks. Particularly if someone's relocated to a hotel, they're not going to be doing their sheets and towels. So actually there might be less laundry. So I would propose rather than $3 a day, a weekly rate for 2 loads. And since the staff said it was $4 to $6 per load, I would go middle of the road at $5 per load. So 2 loads per week. So I would suggest $10 for that rate per week for laundry services. And then finally, I find the wording a little vague on if there is a senior or someone with a disability relocating or not relocating from the building with an elevator issue that they can request services to be reimbursed for. That's kind of open-ended, and I'd like to see some more specificity on that, where we can say that would include meals, dog walking, specific transportation to they have to go out of the building, they need assistance. But I think it's a little too open as worded. And those are my comments.
Thank you, Commissioner. Commissioner Copeland next.
Hi, yes, I just wondered if we could possibly expand on number 4. We're talking about reasonable accommodation for pets that were permitted in the rental unit. We were talking about boarding, basically, the way I understand it. If the temporary accommodation does not accept pets, I would hate to see a situation where, say, we're having an earthquake retrofit and we have to leave for 2 months. And the landlord says, I'm putting everybody up at the Ramada. They don't take pets. Board your dogs and cats in a cage at the vet for weeks or months. I think it would be very traumatic for the pets as well as the tenants to do that. And some pets may have health issues that would exacerbate or that wouldn't work. Is there any way that we can expand on that to say that the temporary accommodation has to accept pets, or make an allowance or an exception outside of the 2-mile radius if the tenant was amenable to it, to be able to bring their pets to a temporary accommodation, rather than having a situation where they have to be separated, particularly with elderly and disabled tenants. I mean, we make an allowance that even if a property does not accept pets, if you're 62 or over or disabled, you're allowed to bring your pets there. So is there any way we could possibly expand on that to make it more amenable for the family to stay together?
Sorry, I think it's possible, but I think it would have to be within within the parameters of your point about it allowing for some flexibility about going outside that 2-mile radius. Because obviously the primary purpose behind this ordinance is to get tenants safely housed,
right?
When there's nowhere safe to live. I can look into that suggestion, but I just don't want to create a situation where there's a lot of back and forth and someone's not being housed promptly because of a dispute over where the tenant should go.
Mm-hmm.
But I understand your point, especially when the extension or the temporary accommodations becomes a little longer than, just a couple of days.
Right. Yeah, I mean, if there's a way to do it where if the tenant is agreeable to the exception of the 2-mile or whatever, I mean, you will come up with the perfect, wording for it. But I just wonder if there's some way we could expand on that, because that really could be, if it's an extended period of time, very stressful for the pets as well as the tenants. So that's the only thing that jumped out at me. Seems very thorough. So thank you for that. That's all I have right now.
Thank you. Commissioner Ayers?
First, I want to just say I agree with Commissioner Bergstein as far as the laundry allowance of $10 a week makes sense. Regarding the $301 per day per household lease, I know that a lot of households may include roommates. And those roommates might not be, a couple, someone in an intimate relationship. They might have a 1-bedroom apartment where, someone has the bedroom, someone has the living room, or maybe they have a 2-bedroom apartment. So I'm just wondering, was there any thought behind what, one household lease entailed and how that $301 would, per day would cover, people with living situations like that?
Well, if the roommate had a lease with the landlord, then that would be another household lease.
Okay.
If the roommate was a subtenant of a master tenant, that creates a different issue. But then again, technically the master tenant would be responsible for the possibly sharing a space, or the master tenant is, the landlord in for that purpose. But I it's a nuance that I'll have to look at more carefully. But generally speaking, I would think usually the landlord is dealing directly with the tenant, but sometimes that's not the case.
Okay, and just one other question. So right now, the West Hollywood Municipal Code does not include any specific per diem specifications? It's
That's
just
correct.
left up to the landlord's discretion at this point.
Right. It's not specified in the ordinance presently.
So this is great. It's definitely a move in the right direction.
Okay, thank you, Commissioner Kurpis.
Yeah, I agree with, I think, everything that I've heard so far. Thank you for doing this and updating this. I think it protects the tenants who are put in a situation where they're unable to be in the comfort of their own home and all their belongings. I do share Commissioner Copeland's concern about the animal, the pet. I think that, especially in West Hollywood, our pets are part of our families, and I think we should give weight to that in determining this. I want to just ask a question about how does rental insurance, does it have any effect? How does it play with a relocation situation like this? Or does it depend on the type of relocation for the purpose of the relocation?
That's a very fact-specific situation. I could see a situation, it's good for everybody to have insurance, obviously. And I know of situations where the landlord's insurance has covered this expense. And renter's insurance will also cover this expense. And of course, as the ordinance points out, if, for example, you have a tenant who has tenant's insurance, renter's insurance, and their coverage will cover this, then provide in writing that that's what's happening, and that's fine. And that's, an acceptable way to resolve the problem. In terms of, disputes between insurance companies over who's going to cover that expense, that has to be fought out between those carriers. Ultimately, though, it is the landlord's responsibility to provide for the temporary relocation. So if for some reason a renter has insurance and the insurance doesn't cover this, then the landlord would have to step in and cover it.
The other thing was the amount that for the per diem is based upon the GSA. Will that go up every year as the GSA changes?
What's proposed in the ordinance and in the resolution is that this figure be adjusted in the same way that we adjust other items through the CPI. So these figures were compiled based on actually the peak from 2020. So it would probably be consistent or perhaps a little bit more than what the GSA provides in the coming years, especially with the pandemic.
Thank you.
Thank you. Commissioner Maggio?
Can you hear me?
Yes, we can.
Yes, my list included food, parking, and pets. I agree that the food budget is a little low unless this particular spot comes with a kitchenette, which would include a small refrigerator. Then I think it could stay the same. Parking, if parking cannot be provided on site, then perhaps the city could provide for a temporary parking permit if it indeed is a parking permit area. And pets definitely have to go with the owner. They can't be separated. So some way we have to make clear and compassionate decisions there. I'm not sure about the laundry. I mean, if it's going to be a 3-month stay, then I would think that there really has to be a laundry budget. If it's a 1 week, 2 week, then I don't think that's necessarily so. So those are my thoughts. Thank you.
Thank you. Vice Chair Kim.
Yeah, sorry, I have a number of them. I appreciate you bringing this. It's got a lot of great and important upgradings. So I apologize, I probably should understand this, but I'm not sure how exactly the per diem in general for housing would work. Would it be that the person says, I'm being displaced and they just get $301 and go find a place? Or would it be that it also says in the ordinance that the landlord pays it directly to the hotel. So would the landlord choose the hotel the person goes to and then pay it directly? And there's a cap of $301, so it could be less, or how exactly does that work?
Well, these are considered reasonable amounts, and the landlord could pick the place. And so long as it's in the range of this per diem, it would be deemed acceptable. The problem we were finding was that in some cases, landlords were going well below market to places that just weren't really acceptable for relocation. Obviously, to hit this figure on the head with every hotel would not be a reasonable ask. I mean, some hotels are going to be maybe a few dollars less or a few dollars more, but this is the reasonable rate that would be that would be considered for this area for housing somebody in a decent place. But as you point out, the landlord is responsible for paying the hotel. Again, the parties are certainly able and capable and should, if they can, reach an agreement that deviates from this in any way. I know of cases where if the work is going to go on for a little longer than just a very short amount of time, where landlords have put the tenants up in other units, which is also specifically provided for in the ordinance, and I think importantly states that they have to be able to stay in that unit, so they're not being bounced around during the displacement period. But the goal behind setting these per diems is to set a reasonable rate for a local hotel.
Okay, and it was at peak time, so I imagine if that's peak, it's going to be lower at off peak, but it's listed in the ordinance, so I'm not sure what that means.
I'm sorry.
The rates that you put were peak rates, right? So it was the busiest, most expensive time of the year that were the rates?
That was what we drew upon. We also drew upon, it's interesting because that peak rate is consistent with Santa Monica's similar rate and ordinance. So I think it is reasonable and a good idea to look to other jurisdictions who have a little more experience. Their ordinance, I believe, was set up in this fashion just a few years ago. So they've actually been raising it consistent with the CPI, and it just happened to fall into that same range, which made staff believe that this is a reasonable rate for this region. I'd point out as well that it's actually the Santa Monica rate that we're using because the LA region as a whole that the GSA relies upon is not really reflective of the costs of staying in a decent place in our area. Santa Monica has its own, it's considered its own region under the GSA figures. So I think it's particularly apt for us to be using something similar to what they're using.
Okay, so if a landlord put somebody up in a really bad place that was way cheaper, then the tenant could say, this is way less than the per diem and what they come to the city and get a citation. You think this language is solid enough that they would have a remedy if that happened?
Yes.
Okay, great. And then I thought that was a really good point that one of the commissioners raised about the question of multiple households. I would think it might not be appropriate to require a master tenant. That might just be a person that's living paycheck to paycheck to spend $300 a day for a relocation. So I personally would consider just making it clear that they don't have to pay. They might have to share the accommodations, but I would be concerned about them financially being liable for that. I think that could be devastating and something that most people would have no idea could be required of them when they're in a roommate situation. I also think that it maybe should vary depending on the size of the unit. If somebody has a 3-bedroom or a house where they have a lot of people, $301 for one hotel room is not going to be nearly enough to give people private, places for that big of a household. So if there's a way, like a suite or whatever, that's what it is for a 1-bedroom, but it would be more for a larger unit. I would suggest having some kind of language to provide for that. I think if we could be a little more specific on parking, I agree with that, that's worth doing. For meals, if there's a way to say, you know, this is what it is, if there's a mini fridge, like Commissioner Maggio and another commissioner said, I think that if a person doesn't even have a coffee pot or a fridge or anything, I think that they would need a lot more for meals. But if they have a coffee pot and a fridge and a microwave, then they could probably do pretty easily on that. I agree, $3 a day seems a little high for laundry, but I don't really think it's that big of a deal. It's not that much. Let's see. For the issue of the elevators being out, right now it's written as seniors and disabled. And like my dad's 65 and he can go up and downstairs very easily. And then there's other people who might be much younger and not disabled, but have like twins and be a single mother that are young, and that it's difficult for them to have an elevator outage for a long time, and that they might have a very, very significant challenge. So I wonder if it would be better to just use language that's tenants whose ability to ingress and egress their apartment is substantially impaired because of the elevator outage. So it would both not be overbroad for people that have no mobility challenges, but also not be underbroad for people that might have unique circumstances that might not be specifically disabled or specifically senior citizens. And obviously I'm just one commissioner, so if people disagree, then we shouldn't make those changes. But I think that was it for my thoughts. And again, I really appreciate it, and these are needed upgrades.
Thank you, Vice Chair. I also had some questions and comments also. First of all, I like the concept of looking into how the city of Santa Monica handles this. And I think that was a good idea. Although I know that other cities also have similar programs, but I think Santa Monica it's explained in the report that makes sense to look into their analogy. And I also like the idea, the mechanism of adjustment of the per diem amounts, as you mentioned, based on CPI, right? You said.
Right.
So yeah, so I think that's a great idea, and I definitely support that. I'm not really prepared to go per, suggest any other figures because I haven't done a research, and I cannot really say if this amount is going to cover or not going to cover the specific service. And I trust you guys, I trust staff that probably obviously did a thorough research on that, looked into the city of Santa Monica, and the report covers that. So one of the questions is, Vice Chair also attached that $301 for the, was it 315 per diem, 315. So yeah, if there is like a multiple bedrooms, 2 bedrooms or 3 bedrooms, and there are like 6 people living, and each couple has like a bedroom, like 2 kids in 1 bedroom, parents in another bedroom, so grandparents in another bedroom. So how this gonna happen? Is there a mechanism for that? Are we gonna require the landlord to, because usual ordinary rooms are, hotel rooms are always accommodations are only 1 room. So is this gonna be like 315 times 3 times? And so the landlord can cover, can provide the same adequate number of bedrooms, basically, or so that's because if a family needs to rent 2 or 3 rooms, this figure is not going to come close to what definitely they can pay for. So that's the only concern I have about this 315 accommodation, $301 accommodation for the families. So definitely we need to look into that if it's if we can cover that. As for the food, the meal per diem 35. Again, I'm not prepared to suggest anything. I don't want to get something out of the blue. 35 times number of people. If it's 1 person, 35, it doesn't seem it's going to cover a lot. It's probably going to be maybe 1 burger somewhere in a fancy place But I'm not prepared to suggest something. If you use Santa Monica's, example, if they have 33, and so far it's been working fine, so 35 could be reasonable. But I don't know if you can look into that, as other commissioners suggested. I have nothing in regards to the laundry facilities, depending on the, how many loads you make. Some people may have a larger family with 2 or 3 kids that would require more loads of laundry. So I think this sounds reasonable. Pets, it seems reasonable too. And I agree with the part about the elevator that you mentioned, as in the report. I support that. And obviously, it's recently we had this letter sent to the council. It is our concern. We want to make sure that, that the families, particularly people with disability or seniors or people with children, they will not suffer this horrible inconvenience when the elevator goes down. So, but I have some other concerns. As the report mentions that the accommodation will be within 2 miles radius, right? Does the Santa Monica require also 2 miles radius, or it's we the city, our city staff is came up with the 2 miles?
I don't recall off the top of my head. I know that we wanted it because of the experience of dealing with these issues and finding that people were being, the current language doesn't specify. So we would receive complaints from tenants that their landlord had placed them kind of well beyond what.
Well beyond that. That's the reason why I'm asking the question. And I mean, you don't have to answer right now. Obviously, you may look into that maybe. If it's 2 miles for Santa Monica and 2 miles for LA, it's still LA, it's still Santa Monica. When we say 2 miles, I don't know if it's going to be West Hollywood. So would that be a problem, or can we, I don't know, can we require that that accommodation will be within the city limits, or it's going to be too much a stretch from the regulation point of view? So if it could be a requirement to do it within the city of West Hollywood, first, we definitely want to make sure that the businesses, the hotels, motels in West Hollywood will benefit from this. And if people are going to stay in West Hollywood, they're going to shop in West Hollywood, they're going to eat in West Hollywood, etc. So that's also economical point of view, and also the fact that they don't have to leave their kind of a surrounding area or neighborhoods. So if it's a possibility, I don't know if legally we can do that. That's one of the questions or concerns. And my main concern is, and what I actually brought up at the first time when we heard this going to come up, is parking. And I know that other city or cities, I'm not going to mention which city or cities, they have this requirement for parking. And I don't really see that is right to not to include parking. We need to provide some sort of remedy. If the landlord is displacing, if we're requiring this, and parking is a major problem, so we have to, as one of the commissioners suggested, I believe it was Commissioner Marger maybe, that if it's going to be in the city of West Hollywood, so obviously it's easy for us to resolve this issue. We can give them a parking permit for if it's a parking zone area, or parking permit for the family to use, but we can't just ignore it. If somebody has like 2 cars and 2 parking spaces, and we're giving them $301 per diem for a hotel, and there is no guarantee that parking will be available, what they're going to do with that is just, it's a huge inconvenience. And I think it is an important thing to include a parking service somehow to find the remedy for it. So that basically all I wanted to share with you, my thoughts and my comments. Thank you for that. Commissioner Bergstein, I saw your hand you raised first.
wanted to address a couple comments made by my fellow commissioners. As far as Commissioner Maggio's suggestion that the city offer permanent parking permits to someone who's parking, I would disagree with that. If a tenant currently has off-street parking, that they should continue to have off-street parking while they're being temporarily relocated. And that be the landlord's responsibility to either pay for parking in the hotel or find a paid lot or reimburse the tenant. But I don't think going from that off-street, maybe secure parking to remedy that with a parking permit is just and fair to a tenant. And then to Vice Chair O'Keefe's comment, we're talking about, if there's a tenant who has brought in, a roommate or, someone they're not in a relationship with, that that person should not be responsible for paying for that relocation. My issue with that is, I think what we're discussing tonight is the legal relationship between the tenant who legally resides there and the landlord. So if a tenant has brought in, a roommate, which is very common in the city, but the landlord has not, run a background check, approved them, added them to the lease, then the landlord or the tenant who has that lease is stepping into that role as landlord. So any relocation, I think, needs to be on the shoulders of that master tenant. That it's not right or just to take non-tenants who have no legal relationship with the property owner and have that property owner responsible for their costs as well. So I would caution that I think what we're addressing tonight is only between the residents of record, the legal residents and their landlords.
Thank you. Commissioner Ayers and then Commissioner Kerpis after that.
I just had one more comment. I'm okay with the meal per diem. And the reason is I think in this situation, we're not expecting the landlord to take over the full cost of meals for the tenant. We're just asking the landlord to supplement the cost of meals because they may be put in a situation where they may not be able to eat as cheaply or inexpensively as they would at home. So we're really the $35 per diem is kind of a it's to supplement what the tenant would normally spend on meals. So I'm actually okay with that. That's it.
Thank you. Commissioner Kerpis?
Yeah, I would agree with Commissioner Ayers on that point. And then also I'm kind of in between Commissioner Bergstein and other commissioners in terms of the number of, or addressing the size of the apartment and the number of inhabitants. And I understand that we want to keep it with just one landlord or one tenant entity with the landlord or one lease. But I think it is different. We should treat a 3-bedroom different than a 1-bedroom if there are bodies in that place to fill it. I don't think that somebody should just automatically get extra money because they have more than 1 bedroom. So if maybe, I don't know, there was like some sort of way to do it that it's based upon per bedroom, not to exceed like the number of adults, so that you might have 2 people there in a 3-bedroom apartment, but you're only going to get for the two adults if they're on the lease. Back to that point about you're only responsible for the people that you lease to. Maybe if there's some way we could do that to find some middle ground. But I also agree that we shouldn't be looking at this as a way to promote business in West Hollywood or a way to help the economy. This is simply to serve the purpose of temporarily assisting in the burden of having to be relocated. So I don't think that we should require them to be in West Hollywood. I think that we should put a limit on the distance from West Hollywood so that they are still in their own community, in the community they live. The other question I had was, this is not a limit, right? So if, let's say during the week before Halloween or the Thursday before Halloween, somebody has to relocate their tenants, they're going to be paying more than $300 a night for any hotel in West Hollywood, maybe even more 2 miles outside of that. This sets like a negotiating rate in a way, just as the landlord can pay much less if they find a good deal or work out a deal with a local hotel, they could also have to pay more. Is that right? Or is this a limit? Is this a cap on what the landlord would ever have to pay out?
No, it's not a cap.
Okay, so it would have to be, this just kind of sets a standard in a way, so people know kind of what they should expect to pay and what the tenant should expect to accept during this time. Is that right?
That's right.
Okay, thank you.
Thank you. Who was next? I saw somebody else raised their hand. Okay, I just wanna, in that case, I just wanna say that, yeah, I would probably withdraw my comment regarding what I said, that it would be beneficial for the economy. It's irrelevant completely. I agree with Commissioner Kirkus, but I still believe if it's possible to accommodate in West Hollywood, to see if it is possibilities, maybe we can urge, or maybe we can suggest, or whatever the language, whatever the legal legality will allow us to do. So maybe we can suggest that would be in West Hollywood. And the reasoning is not the economy, or the only reason would be the area. It is close to the neighborhood. It's close to the schools. It's close to the doctor's office. It's close to the work that the tenants will have to obviously stay close to. Regarding the parking, yes, again, I don't know if that's one of the options that I mentioned. I'm not suggesting that should be the way, giving the parking permit. Clearly, this is going to be the landlord's responsibility to provide the parking accommodation. So I'm not suggesting that the city has to do that. It was just like an idea, but again, the staff will see, obviously, if it's not permissible, if it's not legal, from the legal point of view, it's not going to happen. But definitely, parking accommodation must be, I believe, must be included, in my opinion. So we can't just say that doesn't cover. The other thing is, I don't know if I missed that part, that this ordinance does not preclude the tenant from not paying the rent, right, during this time. So the tenant continues to pay the rent.
They still have to pay their rent.
Right, the tenant continues to pay the rent. So that's also important. I think that basically that's all. These are the questions that I had and concerns. So yes, Vice Chair.
Sorry, just a couple more thoughts. On the distance, like I'm a block away from LA, so lots of places in LA are closer than lots of places in West Hollywood. Right now, it's 2 miles from the border of West Hollywood. I certainly think it would be, if there's somewhere within the per diem amount that's very close to where a person lives, if there's a way to word it so it's like, if there's somewhere within, you know, half a mile or a mile of the actual physical location, that should be preferred. And then if they have to go further out, they can, but it certainly is more disruptive to a person's, everything that you were talking about, Chair, to have to relocate further out, and 2 miles from the edge of the city's border could be an entirely different neighborhood and really mess up people's lives. And I don't know if I mentioned, but I do agree with parking, that if a person has a parking spot, it should be included. And I agree with Commissioner Ayers' point about meals, that it's a supplement, but at the same time, it gets way more expensive to eat healthy meals if you have no cooking facilities at all. So it can go up pretty substantially. Even with a coffee pot, at least you can make oatmeal, you know? And the pets, I definitely agree with too. If we can say that I think it should be that if they have pets, they have to accommodate them, because that would be too disruptive. That's it.
Thank you. Any other comments, suggestions? So what's next? I wanted to ask you, Manager Holub, is there a minimum start and end date for this type of work? Minimum number of days?
Yeah, the ordinance provides that if work is going to go on for more than 6 months, then the landlord would have to initiate a formal eviction, which is an eviction that would require full payment of the regular relocation fees. And they wouldn't be able to recover any of the relocation they used up to the point that they initiated the formal eviction. I'd also point out that that formal eviction, although the tenant would have to relocate on their own using the relocation benefits that would come from a full eviction, they get the right of first refusal. So once the unit is habitable again, they would be able to move back in. They also could, the landlord can also ask the department for an extension if they want to just try to get the work done and they're going a little over.
So the scenario is probably unlikely. Let's say the owner initiates this whole thing and then does nothing, and it lasts for 6 months, and the owner is paying all the per diem and everything. And after 6 months, if we're talking about the a long-term tenant, with a $500 rent, okay, and the tenant stays for 6 months, the owner pays the per diem, and after 6 months, the owner says, okay, so I haven't completed the project, so here's the relocation, goodbye, and the tenant moves out. So and you mentioned the first right of the refusal. That's basically the only protection we have, or there's something else? Because excuse me, I don't want this type of scenario to occur.
Right. So you're talking to basically some kind of pretextual eviction, which would, and presumably, I mean, there's no benefit to the landlord unless they're going to re-rent it from that hypothetical tenant. I mean, my first reaction to that question is that I would refer that to the city prosecutor or the city attorney for legal action. That would be a very serious violation of our ordinance.
So since this is administrated by the city would know, the city would have a copy of the documents, obviously the agreement, and the city will monitor what's going on there. And if that happens, the city will reach out to the tenant or whatever the process is, right?
If we saw evidence of something like that happen, we would treat it very seriously. I mean, obviously we can't know everything that's going on all the time, but presumably if there were some sort of event that made a unit uninhabitable, we would often know about it. And if it was made uninhabitable because the landlord intentionally made it uninhabitable, that would be tenant harassment, and that would be a whole other issue.
And during this process, when the work is being done at the property, so the inspectors will keep it in their radar, that they will go and inspect, see what's happening during this 6 month period.
Yeah, I think that would be very likely because, usually this does start with a code compliance action or activity. Not always. I mean, sometimes it's voluntary because there's something that's, makes the unit dangerous and, the landlord just wants to fix it, rightfully so. But in other cases, there's been some sort of problem that created a code violation and code compliance has to get involved. And sometimes it's things like fires. Or just something like that. And with the fires, we usually find out about it because public safety and or the fire department tell us about it.
I see. Okay, thank you. Commissioner Corpus.
Maybe I missed the beginning of the conversation the two of you just had. Are we talking about we think that the landlord might put a tenant in a relocated tenant for 6 months and then pay them a relocation fee on top of that? And then is that what would have to happen if they evicted them after 6 months? I mean, we have to.
Yeah, if in the hypothetical that was presented, if there was some, let's just say it's all legitimate and it's not being done for a nefarious purpose. If there's just so much work that needs to be done that it's going to take months and months. the code provides for, there's a provision in the code that provides for an eviction that will, where the tenant would be required to be paid the full relocation benefit. The tenant would have to use that to find alternative housing through the duration of the repairs. And then when the unit was ready to be reoccupied, that tenant would have the choice as to whether or not they wanted to reoccupy it, obviously at the
I just don't see this happening. I mean, that's costing thousands and thousands of dollars for the landlord. Right.
I don't think this is something that we've encountered.
Yeah, I mean, it just doesn't pencil out. It's $56,000 to keep someone in some place for 6 months at $300, and then it's going to cost another $25,000 or $30,000 to evict them. So, or to relocate them from that. So I don't really think that that's, something we have to worry about tonight. That was my only comment. I just wasn't sure where we were going with that. I thought I had one more point, but I forgot it. So,
yeah, but that's not something that is I'm suggesting that's going to happen or might happen. That's a possibility that
good for the tenant.
we have to cover. We have to cover that possibility also. So then make sure that again, that's a hypothetical, unlikely hypothetical, but it has to be a mechanism to protect the long-term tenancies or
that would be protection.
RSO tenancies.
Yeah, I would say $70,000 is good protection.
Okay, so the manager explained already, and keep in mind the tenant continues to pay the rent, and the tenant being dislocated to a hotel room. So that's a huge inconvenience and the whole thing connected to it. So I'm satisfied with the manager's response. Any comments? Any other suggestions? Somebody raised their hand.
Clarification question for staff. I thought you earlier said that, so in the hypothetical where a tenant has been relocated for 6 months or more, the landlord can then initiate a no-cause eviction and pay relocation fees. But I thought you said, or maybe I misunderstood, that the relocation fee would be reduced by any cost of the landlord. Did I not hear you correctly?
It's the opposite. They couldn't recover for what they've already spent.
Thank you.
All right. All right. If there are no more questions or suggestions, so I would. This is what we need to do, right? We just need to. Okay, let me ask you, Mr. Manager. So, what needs to be done here? Are you going to make some updates and then come back and then we vote on that formally? Suggest to present to the City Council, or how this is going to work?
No, I think that from what I've gathered this evening is that, there's a desire to move forward with this, and what I will do is integrate those suggestions that I can and that I think should happen. And if I don't put in everything, the council will know what was suggested that I didn't put in. So they're going to be aware of it. So if they disagree with staff's ultimate recommendation, they'll know exactly what the commissioners recommended. And then they can make the final decision about how this ordinance will be crafted when it becomes a final product, as is always the case.
So you're saying that some of the recommendations will be incorporated into what you already prepared, or
well, I can't decide tonight.
Yeah, I'm not saying tonight. Yeah, yeah, I'm not saying.
But they're all. First, let me just say that these are excellent points, and some of these I certainly am already considering. Will be integrated into what is presented to council. If there's anything that staff isn't totally in agreement with what was suggested tonight, that will be reported in the staff report. And we will be very specific that a commissioner or the commission recommended, something that staff is not presenting to council as a recommendation. And if the council disagrees with staff and agrees with the commission, then they can certainly make that determination at the time that they're presented with it. But I would prefer to move forward. My plan is to go over, I think I took pretty good notes, but I might have to go over the recording again and make sure I know all the suggestions that were made, integrate everything that I think I can and can work, both in terms of what we can do and what's enforceable, make that present and bring that before council at its April 5th meeting, which is only one meeting after this next one.
Do you think this might come back to the commission after it goes to the city council or whatever? Or you
My
cannot
experience would
guarantee?
be, so long as I'm integrating everything and telling council what was said here tonight, and they have a chance to thoroughly discuss it themselves or consider what was presented to them, there probably won't be a need for that. But ultimately, that's council's decision. If council directs staff to return it back to you for more discussion, then obviously that's what's going to happen.
And can we get a copy of what will be presented to the council?
Yeah, I can
you know,
have
what was left out.
But I will make sure that our commission secretary gets that to every commissioner before it is considered by council. It won't be available until it's actually agendized, but I will make sure that you see it. So if I would imagine you want to speak to your council member, so to speak, or the council as a commissioner or as a member of the public, then that's the way it should be.
So for the same reason, I was just, I thought it would be a good idea at the time when you are presenting to the council. So maybe staff could email it to us so we can review to see what is going to be submitted to the final version that is going to be submitted for the council review. So if the commissioners will find, necessary to speak to the council people, council members, so then they know what was presented and what they're going to discuss. Although if there is a chance that this can come back to us, so we have to be, I guess, careful what's going to be discussed and how. But that's just a thought. I saw Commissioner Ayers, you wanted to add something, and probably we'll conclude our discussion.
I'd just like to make a motion if discussion has concluded.
Okay, so so I think we've done with our suggestions, recommendations, and the discussion on this topic. And then we don't need a vote on this, right, Mr. Manager? Or we do need to vote?
That's at your discretion. Yeah, I mean, you can formally recommend it if you'd like, but I also, if you don't have to make a motion. What I will do after this, regardless, is integrate the suggestions as is appropriate and bring it to council. If you'd like to make a formal motion recommending it with the suggestions that have been made tonight, that's fine too, and then I'd report that to council.
I think I would be fine with it, but the thing is, typically when we vote on the motion, go member by member, we want to see what's specifically what the language and what is it in the document if we're going to vote on that.
I think we just accepted file.
Yeah, so I would say that since it is also on the agenda, instead of voting on this, I would just say that the recommendation will be, the recommendation of this commission is to move to recommend to the City Council approval of the proposed amendment to section 17.52.110 Rent Stabilization Ordinance and the attendant resolution with the recommendations and suggestions from this commission. Would that sound right? Would that make sense?
That's what I was going to move.
Okay, but we're not going to vote on this, right? I mean, again, commissioners, what do you think? So let's just ask, do you want to vote on that or just?
I feel like Commissioner Ayers should have been able to finish her motion and make it.
Oh, you want to? Okay, all right. So then, yeah, I thought the reason why I thought that I didn't want to vote on this because I don't have actual document what I'm voting on. Because the recommendations and all the suggestions, I trust the staff is going to do the best, and there's no question about it, to include everything. But typically, when I vote, I want to see what I'm reading and what was included that I'm voting on. But okay, it seems like we want to make a motion. Then Commissioner Ayers, go ahead.
I move to recommend to the City Council approval of the proposed amendment to Section 17.52.110, the rent stabilization ordinance, with the staff considering the suggestions and recommendations that we made tonight.
Sounds great. We have a motion. Do we have a second?
I'll second it.
Okay, we have a second. Any further discussion on the motion?
Question for staff, does that work for you? I'm supportive if it works for you.
Absolutely, thank you.
Okay, wonderful. Any other comments?
Voting on it because I haven't seen the document, so I'm more in favor of receive and file. We've made suggestions, but I'm concerned about adding a vote. I think staff will do a fine job on it, but I'm concerned about voting on a document that I haven't seen.
So procedurally, should that be a substitute motion, or is that just a you're voting no for that reason?
Receive and file is what we normally do on these issues.
Because we have a motion as the commission has requested. So now Commissioners Bergson and Maggio, I feel the same way. But if we vote against this motion, it will be like we're not supporting the whole thing. So it will sound that way.
Could you repeat the motion, please?
Can we amend the motion, or if you want to come up, not amend, but can you come up with a alternate motion?
The motion fails if there's not a second.
I already seconded it, but I think procedurally.
No, there is a second. Procedurally, we can have an alternate motion. Anyone?
I want to know what the motion is again, please.
The motion is to move to recommend the City Council to the City Council approval of the proposed amendment to Section 17.52.110 of the Rent Stabilization Ordinance, actually the Rent Stabilization Ordinance, with the suggestions and recommendations from the Commission that staff received tonight. That was the motion, right, Commissioner Ayers?
Mm-hmm. Yes.
I would make an alternate motion that this be a receive and file.
I agree.
Is that a second? Is that a second?
Okay, you made a motion, alternate motion to receive and file, and Commissioner Maggio seconded. So we vote on the second motion first. How we do it? Yeah.
But you don't need to vote on a receive and file. You just accept the fact that it's received and filed.
But
now it's a motion.
This is a motion.
All right, so therefore it's a motion, and it has been seconded. Okay, I guess call
Commissioner Bergson. Commissioner Bergson made the motion to receive and file, and you seconded. So that's a motion. So now we need to vote on that.
I call for the vote.
That's what I'm doing. So I'm saying that we have a motion and we have a second. Now, Mr. Secretary, can we have a roll call on that alternate motion, which is receive and file, with the recommendations, obviously, that was presented tonight?
Commissioner Bergstein?
Aye.
Commissioner Copeland?
Aye.
Commissioner Ayers?
Aye.
Commissioner Kerpes?
Aye.
Commissioner Maggio?
Aye.
Vice Chair O'Keefe?
Aye.
Chair Topshin?
Aye. So then it's receive and file, and with the recommendations. Thank you, everyone. Thank you, staff. Thank you, Mr. Manager. This was really thorough and very interesting discussion, and a very important addition to the municipal code that is probably long overdue. And we appreciate the discussion and bringing this to our attention. Thank you. All right. So with that, we're moving to the next item, which is public comments. Mr. Secretary, any speakers at this time?
No speakers.
No speakers. All right, no speakers, and the commissioner comments. Commissioners who would like to begin?
Mr. Chair?
Yes, Commissioner Maggio.
I didn't welcome the new commissioner. welcome.
All right. Commissioner Vice Chair O'Keefe.
So I believe that, Chair, you had suggested maybe agendizing the issue of the smoke-free housing ordinance now that it's been adopted in a modified way. I would be in support of that. So I guess, assuming I heard you right, I would make a motion that in a future meeting, we agendize a discussion of that, which could or could not include some kind of additional recommendations to talk about what exactly passed and next steps and any thoughts we might have on it. So that's a motion.
That's a motion.
That's a motion to agendize a discussion on it, if anyone seconds it.
Well,
Second.
I'll second it. Oh, who seconded?
Commissioner Copeland did.
Commissioner Copeland, you did? Okay, so, Vice Chair O'Keefe made a motion to agendize the future items that are going to, or specifically smoke-free apartment.
Yes.
Specifically smoke-free.
And just ask for a clarification so that
Okay.
staff brings you something useful.
Yeah.
What do you want a presentation on what it is? Is that what you're looking for?
Mostly, and just to have a space to discuss it and to see if we recommend any changes. Is it final or does it need a second vote?
It's going to second reading on the 15th.
So there's no time between now and then.
There's no time.
Okay.
No,
This month, 15, right? There's no time.
The city council is obviously I don't know what's going to happen on the 15th, but it is up for a second for its final vote on Monday.
Okay. Yeah, it's just to discuss it. And one thing in particular I was interested in is what happens if somebody's disabled and lives in a walk-up and is a smoker, because I did some Meals on Wheels and there are people in that situation. That was my number one concern, but it was mostly because the chair had brought that up. And, you know, if there's $100 after 100, I don't know what the penalty is. I could just listen to the debate on Monday, so I don't feel strongly about it, but it seems like since it originated in the commission, even if I was hoping it would be before it was totally final, but I still think it's worthwhile to hear a presentation from you. And then if we have further thoughts that we want to recommend, even though it would require changing an existing ordinance at that point.
Can we ask, Mr. Manager, if the council is not going to vote and if it goes back to staff, which is, you know, that could be a possibility also, can you bring it to the commission review on the next meeting on the 25th? Or whenever, or maybe April, if it's not going to be scheduled this month after the 15th.
I would wait and see what happens.
Okay.
I know that it's already been polled and then revisited once, and it's 4 of the 5 council members passed it on its second when it was revisited, and it's a consent item on the next agenda. This is just my suggestion, and obviously the commission can agendize it any way it sees fit, that we wait to see what happens on Monday, and I'd be happy to come back with a presentation about what it is, and then any further discussion can be had, but at that point, and at this point, for all intents and purposes, this has been vetted. So I'm not sure where what beyond a presentation we'll be doing, but it's not staff's intent to revisit this in the short term after a lot of work has gone into it by other staff in other divisions, and the council has presumably already reached a conclusion. So I don't want to convey that this is something we're going to revisit in this commission and then send back for a lot of changes or even some changes right off the bat. It's not even fully implemented at the outset. So I suggest a presentation on what it is so that the commission and the public can be informed. And then if we want to revisit it at a future date after some enforcement and some actual real world experience has occurred, that might be the ideal approach. But ultimately you tell me how you want to agendize it, and that's how it'll be agendized.
So for the motion, how about it's a presentation if the council has already acted, and if it hasn't acted, it's a presentation. And I just want us to have the authority if we wanted to pass some resolution for it to have been properly agendized before we pass the resolution, just in case we want to.
Chair, may I?
Sure.
I think we're putting staff in a potentially awkward situation asking these sorts of questions. I think what we need to think about as a council is what our authority is, what has already happened. The council has already acted and is in the middle of an act that I've never seen a situation where on second reading, well, I have, but very rarely would you ever see a second reading be pulled and decision reversed. I think that what the staff suggestion was actually excellent, that we ask for a review or a presentation, but not make it an actionable item. And then, whatever the future holds, the future holds. Someone can make a motion in the future. I think it'd be way too soon and ill-advised, but we could deal with this issue later, any actionable items that someone might have later. But bringing it back for a presentation, I think would be good for everybody, because it has changed.
Would that be okay with Vice Chair O'Keefe?
I still prefer it to be agendized in a way that allows for it. I don't think it's likely that we would take action, but I'd prefer to keep it open, even though it's unlikely.
Okay, Commissioner Bergstein?
I will be voting in opposition to the Vice Chair's motion. Having been a part of this process since day one, I can tell you it has been thoroughly discussed with all council members. I agree with staff that 4 out of 5 council members made their decision. I think, Vice Chair, you're putting the cart before the horse. I think it wouldn't be a bad idea that once city staff has brought together the educational component to go out to tenants and landlords, to have that presented at the commission. And then if there are issues that staff is finding in implementing it later on down the road, that might be a discussion for this commission, perhaps. But I would say that this would not be a well-advised time to try to rediscuss this and bring up more decisions to council. I would be in favor of, when staff is ready to send out the educational materials to all the landlords and tenants, that could be presented to this commission. And then if there are issues that seem to be arising that code compliance is having questions on, that could be re-agendized. But right now, not an appropriate time.
So can I ask the manager, does the ordinance apply to people who are disabled and cannot physically walk up and down their stairs and smoke in their home? Would they be in violation and fined every time they smoke?
I don't think there's any carve out. I'd have to look at it again.
Okay. Well, I think that would be unfortunate and wrong to punish somebody who's physically incapable of walking and isn't a walk up. So I would prefer if it ends up not being debated. I don't think that was something that was discussed. This did originate in this commission, and I've been on the commission for 2.5 or 3 years, and it was before I was on it. So the current members, many of us didn't weigh in. And if there wasn't a carve out for that, I don't know if it wasn't thought of, or if it just was thought of and the decision was that person will be fined an excessive amount, even though they already lived in their household. But I do think that that's an injustice, and that it would be a mistake to not raise it if we might have the opportunity to.
Mr. Holub, if on the 15th it's not going to be voted on, that ordinance, would be that possible still for us to review for additional recommendation, or that is not?
No, I mean,
basically I'm hearing that you're saying that's not what you would like to see happening.
I do think that that the appropriate approach, given that it's pending before council right now on second reading, is to see what happens with that, it's not going to come before this committee. It's not a possibility for it to come before this commission before Monday, obviously. It could be enacted into law on Monday. It's on consent calendar on second reading. So at some point in the near future, I could come back and we could talk, in a presentation, the specific issue that Vice Chair O'Keefe brought up, I could, look at more thoroughly, and this commission can discuss whatever it wants to discuss on an agendized item. But it's not part of my work plan right now to revisit an ordinance that is on the precipice of being enacted, and that was worked on and vetted by other divisions and the city council. And so I just have concerns about reopening it from kind of, the perspective of we're going to be making recommendations right away on a new piece of legislation that the council is in the process of voting on, basically.
So what you're saying is basically whatever happens on the 15th, later on we can, if it's passed, if it's approved by the city council, so we can have this discussion initiated at this commission, and you can make a presentation and we can make a recommendation to amend it, right?
Right, and I just want to make one important point that I think, is pertinent to what we're talking about, and that's that this enforcement is not going to start right away. There will be, I think, there's going to be an education and an outreach period. There's time to have a presentation, certainly, before anything actually starts to happen in terms of sites being issued.
I make a substitute motion.
Before we go there, Commissioner Brookstein. So I want to understand the technical part. Because I see that's what Vice Chair suggests. It's a very important issue that unfortunately for some reason it was overlooked, or we didn't include it, or we didn't think about it at the time. But and that's also my concern. But can we? And I don't want to change the structure right now because it's ready for the city council's vote, and most likely it's going to pass, and they most likely going to vote. So I don't want to do it right now to do anything like that. But I want to know if we could look into this later on and propose amendment to whatever is going to be passed, if it's passed on the 15th. Later on, do the research, get the presentation from staff, and suggest and recommend an amendment to the existing at the time ordinance. Is that a possibility?
Sure. I mean, this commission can put forth, a consensus,
okay,
if it wishes to, on an agendized item. I would just caution that, I don't think there's a need to, or a benefit to doing that prematurely or like right away. It's not something that we can't rush back and make a thorough, thoughtful presentation on this on the 25th, and it's already after the fact probably. Okay. So I would, if I was going to come back and talk about it, or have other staff from other divisions come back and talk about it, I'd like to be able to do so in a way that's thorough and, really addresses what staff is looking at in terms of enforcement and education.
Okay.
Yeah. Okay, I'm okay with changing my motion, I guess,
okay,
and just being what you suggest you present at some point in
okay,
time. I'll just let the council know my concerns separately.
Yeah, I think the commissioners, if you have concerns, if you want to reach out to your council member, or if you're at large, if you have concerns, you can reach out to everybody. At this point, thank you, Vice Chair. So maybe we can see how this is going to work. it's not going to immediately affect, obviously, and if we're gonna monitor maybe, and we're gonna request staff to provide some information or some reports on some presentation, and because that's a very important thing that you brought up, Vice Chair, and I would have definitely supported that idea, and that's also my concern, and I have other at least one or two maybe concerns also that I would have liked to be discussed and reviewed.
Point of order. We're just debating whether to put this on the agenda or not.
No. That's I'm responding to Vice Chair O'Keefe. Already withdrew the motion, right? As I understood.
Or just mod. I guess we don't really need a motion.
We don't need it. We do not need it.
Manager Howell will just come at some point on his own and present on it. I don't know if we need a motion for that.
So that's what I was saying, is that maybe, we can see what happens and we can come back at a later time.
Mr. Chair, if I can make
Commissioner Bergstein, you wanted to say something.
Just that we would ask staff that when City Hall staff is ready to send out the educational component, including details of the ordinance, as well as smoking cessation policies and services available, that at that point, when they are ready to send it out to public, that it be agendized for a presentation at the commission level.
Yeah, and I can do that.
Thank you.
Thank you. All right, so it seems, well, other commissions, did I ask everybody had a chance to speak? Commissioner Copeland?
Yeah, I just wanted to say thank you to our acting Housing Director Holub for his hard work on trying to help us amend and tighten up that, because I've gotten responses from him at all hours, the wee hours of the morning and the night. So I know he's working very hard, for all of us. And I appreciate his and staff's efforts very much. And that's all I have. Thank you.
Thank you. Commissioner Ayers?
Nothing.
Nothing. Commissioner Purpose?
Yeah, just I would echo what Commissioner Copeland said, and again, welcome Commissioner Ayers and Vice Chair O'Keefe. I'm not I wasn't trying to be adversarial at all. I just want to protect the integrity. I mean, and based on when we've worked together, that I'm a huge advocate of the commission doing what we want to do and getting our voice heard as a body. But I just think that there's also a time when we've moved it on, and I voted against it, by the way. But when we move it on, that to save credibility and have the council continue to respect what we have or what we send them, that we don't get into a fighting match with them, because they'll win and we'll lose big time probably. But I just want to let you know that I wasn't trying to be adversarial. I was just concerned about that last little part about taking action so immediately. But a presentation is perfect.
Thank you. Commissioner Maggio?
No further comments.
Okay. Vice Chair, anything? In addition?
I guess I'll just respond.
Okay.
I understand Commissioner Kirby's, and I just, with most of the council members being brand new, and a lot of us being new since it was considered, like I said, I just felt like it was might have been a little half-baked and some things not thought of, and trying to hopefully save people from that. But it sounds like the ship has sailed, unfortunately. That's it.
Thank you, Vice Chair. Commissioner Bergstein, you spoke, right? And commission comments. All right. And I have nothing else to add. Other than that, I want to thank again staff and Manager Holub for this really detailed and very thorough and very informative information and the report on the temporary relocation ordinance. I think that was very important, and thank you for that great work staff did. Appreciate that. All right, with that, staff comments, anything else from staff?
Just thank you for the lively debate this evening, and Commissioner Copeland for your comments. And I'd just like to say that, it's the entire staff of the Rent Stabilization and Housing Division as well is working really hard under really challenging conditions right now. It is a difficult situation working remotely, and some of our staff do actually go in, and that's risky. And I just want to express my appreciation for how hard they're working and how much support they're giving me as I'm navigating my way through this acting role. But thank you for your kind words, and thank you for everything that all of you do to serve the city. Appreciate it.
Thank you, Ms. Manager. All right, with that, we conclude that concludes our meeting tonight. And commissioners, the next regular meeting of the Rent Stabilization Commission will be held at 7 p.m. on March 25th, 2021 via teleconference. Thank you, everyone. Good night. Stay safe.
Good night, everyone.
Night,
Take
all.
care.
Stay healthy.
Good night.
Good night.
And,
Bye, Rob.
Thank you.
bye, Rob. We'll see you next.